So now I would like to introduce our presenters and our topic. Today we're having this presented by the Disability Law Center, the attorneys Rob Denton and LauraLee Gillespie. They're going to be explaining eligibility requirements and processes for getting assistive technology in the world of Medicaid, Medicare, private insurance, vocational rehabilitation, and special education. This webinar will help you understand what is required to qualify for assistive technology services and common legal issues the Disability Law Center has addressed concerning assistive technology. Rob Denton is a senior attorney at the Disability Law Center. He has practiced in various issue areas during his 26 years at the Disability Law Center, including access to various assistive devices through Medicaid, Medicare, and private insurance, special education, and vocational rehabilitation services. Denton must love working at the Disability Law Center since he's been there since 1988. And then LauraLee is also an attorney at the center, and her practice focuses in special education and vocational rehabilitation disputes. As a former public educator, she brings a unique understanding to her work with the Utah Department of Education. Gillespie received her bachelor's degree in elementary education from Weber State University in 1996. While teaching, she received her paralegal certificate at the University of Washington, a 2011 S.J. Quinney College of Law graduate, and a 2012 Utah State Bar licensed attorney. Gillespie loves the work she has been involved in at the Disability Law Center since 2009. And again, if you have questions as we go along, please feel free to send those on to me. And if you have questions you feel may be unrelated or more general, you are welcome to save those for the end, and we will have a Q&A session at the end. And now I will turn it over to Rob and LauraLee.
Thank you, Story. Couple of things first. We are the Disability Law Center. And those of you who are not familiar with the Disability Law Center, it is the protection and advocacy unit for the state of Utah. That means that we cover everything from Box Elder to North San Pete to St. George. We have had cases in all of those areas. Some things just to know, we do work in abuse and neglect, access and rights, education, employment. So if you ever have a disability discrimination question, it's a good place or resource for you to call, because all of our services are free of charge and are funded through federal grants and private donors. Rob and I are both attorneys, but we are not providing any legal advice during this presentation. We're giving you what the law says, and we are going to provide you with some experiences that we've had in the work that we do. Also, if you have very specific questions about your individual situation or a client or a child of yours, we would ask that you would call us at the Disability Law Center or send an email at our website, as we really don't have the time to respond to those right here. And again, the question of legal advice comes into play. So just to get started, we want to just kind of go through assistive technology from the legal perspective. Assistive technology, an assistive technology device was defined, and for some of you this is going to be old news, for others this is going to be brand new, but wherever you're at, it's always good to review what we already know. So the Individuals with Disabilities Act of 1988, which I believe was when Rob started at the DLC, Yep. Defines assistive technology devices as an item, a piece of equipment or product or system, and you can read through that, but to increase, maintain, or improve functional capabilities of an individual with a disability. I found it interesting that even though we've changed in terms of technology quite a bit since 1988, the definition is still the same. And I think it's important to note that it's more about what it's used for than it is about what the object actually is. These are some common devices that we've dealt with in our casework. This is not an exhaustive list. There's several things that could go beyond what's listed here, but these are some common ones that come through in the cases that we deal with on a daily basis. So this just gives you an idea of that. Device and service are two different things, and we'll talk about this in more detail in terms of the actual legal impacts that it has, but services means a service that directly assists an individual with a disability in selection, acquisition, or use of assistive technology. And this can include training to individuals who are working with the person who is providing the assistive technology, whereas a device is an actual object of sorts, whether that be a chairlift to a computer, whatever the need may be. Examples of services, again, because this is different. So an evaluation, this is common in a school setting, a functional evaluation for the needs in terms of education, and we'll go into the specifics of that later. It happens quite a bit as well in vocational rehabilitation. Rob, do you have anything about the...
Well, and, just in the context of health insurance, we'll call it that, okay. Assistive devices can run the gamut from something that's necessary for a purely medical need. It could be something that makes the person more independent in their everyday life. Okay. All sorts of things.
So here's other examples: purchasing, leasing, or otherwise providing the acquisition, depending on the eligibility for the program that you're working with. And again, there's a wide array here, and we're going to scratch the surface. And so just recognize that if you do have questions, whether it's specific to what we're talking about right now or more detailed, you're always welcome to call our office for further technical assistance. Selecting, fitting, customizing, these are all examples of services, not the actual device itself. Coordinating use, therapies, training or technical assistance for professionals as well. That could mean, in a school perspective, it could mean the aides that work with the child, and should mean the aides that work with the child. In an employment situation, those who are either a job coach or someone who is somehow directly connected. Costs vary, and this is a very generalized cost. Some of you are looking at these thinking maybe it's a little bit more than that, and you're probably right.
They've gone up.
Yeah, but this is according to Ken Reed from UCAT, the Utah Centers for Assistive Technology, in 2010. And again, like I said, this is very generalized, but these are some common things that are used for assistive technology purposes.
Mm-hmm. And it's always been interesting to me how prices, you can have simple devices, and it might just be a modified spoon with a different grip, and that's something that should maybe cost $10 to a very expensive wheelchair or speech augmentative communication device. It's runs the gamut. Right.
Okay, so funding sources for assistive technology, which is really where we're somewhat focusing today. Medicare, Medicaid, private insurance. Rob's going to cover those areas, and I'm going to cover the independent living, vocational rehabilitation, and special education, and how that works. So we'll go ahead and get started. But in all of these cases, there's usually a pretty clear three-part test, and it's right here from the legal standpoint. First of all, is the individual eligible for the program, whatever program that may be? And again, we'll walk through those different programs. The second is the requested AT a covered benefit? So is it somehow related to the services that they need, and the expenses can be covered? And is it necessary for one of the following reasons below, which medical, independent living, employment, being able to do a job, and having accommodation through assistive technology and education? So that's a very general three-part test in terms of how to go about looking at what you're asking for and saying, does this person qualify for those assistive technology needs? So we'll go ahead, and I'm going to turn it over to Rob for a little bit to go through the healthcare systems.
Excuse me. And I just want to say that if you have any questions as we're going along, send them to Story as they come in. They come up in your mind, and we will try to answer them as we can as we're talking, if they come in during that point in time where we're on that subject. And if not, we will try to cover those at the end of the this webinar. So anyway, healthcare systems. I mean, we're essentially talking about health insurance. We're Medicaid, Medicare, private insurance. And hopefully now, particularly with the ACA, most everyone out there is covered by any one of those three sources of health insurance. And with any of those three options, it comes down to, as LauraLee mentioned, you either have to be Medicare or Medicaid eligible. Whatever the device is has to be a covered device under either one of those programs or on your individual private insurance policy. And then it has to be medically necessary. And that's a term of art that's used in all three of those contexts, and we'll talk a little bit about those. Next slide. Medical necessity. So let's start out with the Utah Medicaid program's definition of medical necessity. And I understand that this webinar may be viewed by people outside of the state of Utah. So I should say that each state Medicaid agency has its own definition of medical necessity. What I'm going to talk about and what I'm going to give you is the definition for the state of Utah. But if you're in Idaho, Wyoming, or any other state, your state Medicaid agency may have a different definition of medical necessity. The ones I'm familiar with are pretty similar, but I have seen some that really are distinctly different. And so there may be issues that come up in, I don't know, Tennessee, under Tennessee's medical necessity definition that we wouldn't necessarily have to deal with in Utah. So that's going to vary somewhat from state to state. But on your screen is the Utah definition, and this is for adults. It's reasonably calculated to prevent, diagnose, or cure conditions in the patient that endangers life, so forth and so on. And those are pretty broad terms, and most all of the providers, the therapists, whoever that are going to be evaluating for and recommending various devices are able to fit the need into that definition. You may have to think about it a little bit. You need to refer to that definition sometimes as you're writing up your medical necessity evaluation. I'm going to talk about medical necessity evaluations a little bit later, but I'm just giving you the definition right now. And then the other criteria is that there's no equally effective course of treatment available that's less costly or more conservative. And this is the definition for medical necessity for children. And the first part of it's a little different. The second part is the same. If you look at the first part, you may think that, well, that on its face, it may be essentially the same as the definition for adults. In reality, that is defined more broadly by our state Medicaid agency. It's a little easier to slip things into that criteria than it is for adults, and I suspect that it is the same for other states, since under the Federal Medicaid Act, there's a real emphasis on trying to get services and devices to kids. So that's going to be defined pretty liberally and used pretty liberally. So under Medicaid, most all assistive devices are going to be considered either durable medical equipment or prosthetic devices. There's only, off the top of my head, there's only one thing that I can think of that could fall within a different category of services, and that's a speech augmentative communication device, which could be considered, which could come under speech language services in a state Medicaid plan. So there's the definition of durable medical equipment. And each state Medicaid agency is able to define durable medical equipment as they choose to. Again, I think in most states are probably pretty much all the same. Utah's is the same as the Medicare definition of durable medical equipment. Yeah, you can go to the next slide. And as I say, the other main category is prosthetic devices. And there's the definition of prosthetic devices: replacement, corrective, or supportive devices, so forth. Artificially replace a missing portion of the body, prevent or correct physical deformity or malfunction, support a weak or deformed portion of the body. Now, the interesting thing about these categories of services, and really maybe the only reason for me to talk about them, is that a particular piece of assistive technology, assistive device, can fall within more than one category of services. And we have had cases where whether something is covered or not can become a question of which of those categories of services. It can be considered whether it's a prosthetic device or durable medical equipment. And some devices, these are pretty broad definitions. Some things can fall within more than one, such as a wheelchair. That can be considered either durable medical equipment or a prosthetic device. A speech augmentative communication device has been found by courts to fall within either a prosthetic device definition, durable medical equipment, or speech language. So we play around with that sometimes as we're making our legal arguments, and that can make a difference. And I'll talk to you about that a little bit later, about how you might be able to use that as you're trying to figure out either how to code something, how to request it, or maybe when to call us if you're having problems with finding the right code or getting it approved because of the category of service it's defined as. Medicare, here's the definition of durable medical equipment for Medicare purposes. And as I said, it's the same as Utah uses. The one interesting thing about Medicare that makes it, I think, somewhat challenging for vendors and healthcare practitioners, at least, is that Medicare is a reimbursement program. So it's like private insurance. You get reimbursed for the cost of the device or service after you've provided it. Whereas in Medicaid, for so many of the services and devices, you get prior approval. The difference is, particularly when you look at, contesting a denial, with Medicaid, you ask for approval and it's denied or granted, and then if it's denied, you go ahead and appeal. With Medicare, you're in a position where you've got to provide the service or purchase the device before you necessarily know whether you're going to get paid for it, or you're going to have to pay for it out of your pocket. And that's the same case as with private insurance. So that can be a problem for some people where they're asking for a device or a service that's not as traditional, as standard, as the normal device. And it involves, for some people, getting it and taking the risk of being paid for it once it's provided. And, same standards, eligible for Medicare, it's a covered device or service under Medicare, and it's medically necessary.
Do you want to talk to private insurance
Yeah.
before I move on?
I didn't create a slide for private insurance, and I don't know how much there is to say about private insurance because it's going to be based on whatever insurance policy you have. So some devices, some assistive services may be covered in one policy and not another. So obviously. You have to look at your policy to decide whether you're going to be eligible for reimbursement for that particular device or service. And the other thing is each policy is going to have a different definition of medical necessity. So for the person doing the evaluation for the device or service and the vendor, they're going to have to know what that individual policy says about what is, how it defines medical necessity as you're looking at writing your evaluation, making your request for the reimbursement for the device. So you make sure you use all the right language and all the right criteria for demonstrating medical necessity under that individual policy.
Great. So now I'm going to talk. Oh, go ahead.
So we have a question, the same question actually from a couple of people. Is a ceiling lift ever covered as durable medical equipment for a child with Medicaid and private insurance?
Ceiling lifts are covered, and I believe they're covered under as durable medical equipment. And there are going to be issues, just as with anything, about ceiling lifts, whether that's necessary as opposed to, say, a Hoyer lift or some other type of lift. And at times, we've had cases where the Medicaid people want to actually have pictures or whatever of the home to make sure that the ceiling lift is going to be able to work, to be able to get the person from one room to another room, and specifics about the home like that. But it is covered for children, and it should be covered for adults also.
Okay. Well, independent living centers, we're going to move on to that now. Those of you who are not familiar with independent living centers, there are 5 or 6 throughout the state. I want to preface the next 3 areas, the vocational rehabilitation and special education, with I am coming from the perspective of someone who's dealing with a client who is wanting to pull their hair out because they're frustrated and they're not able to get what they're needing. So keep in mind that as I'm talking about this, it's coming from a role of someone who's trying to help someone get the things that they need. So independent living centers are there to help people with substantially significant physical and mental disabilities that impair daily living. So there's a whole lot of legal arguments just in that right there. Substantially significant, that impairs the activities of daily living. We know, according to the ADA, that daily living is pretty much everything, the ADA being the Americans with Disabilities Act. Breathing, eating, working, going to school, all of those kinds of things. But in this case, it has to be substantially significant. And there's a reasonable expectation that the services provided will be beneficial in the move towards increased independence. Now, independent living centers are not highly funded, and they're usually a place of last resort, meaning that they want you to get services elsewhere first and come to them last. That being said, though, they're still there as a resource for us that's available. And if we can show that this is a substantially significant disability that is impairing activities of daily living that require assistive technology, then there's an argument to be made that they can either completely support or provide something towards that needed assistive technology. This is some ways that this is kind of how it looks to be more independent in the home and the community. There is an income requirement. It is, like I said, a place of last resort. The supports and services are assistive technology coordinators that can assist in determining the types and costs of assistive technology. Assistive technology loan banks. Now this basically is providing you an opportunity to try things out, see if they work for you. They can help you pursue funding, and they can purchase AT when appropriate. Like I said, again, this is not their central focus, but if we can show that there's a need for it for daily living, there is an argument to be made that this is the appropriate place to help fund it.
One of the things
go ahead.
about independent living, you know, when you talk about independent living as a place of last resort, at least as far as assistive technology goes, independent living rehabilitation services, they're not an entitlement service.
No.
You know, like Medicaid and Medicare, if you are eligible for those, if there's particular service or device within the plan, and if it's medically necessary for you, you're entitled, you're legally entitled to that device or service, and you're entitled to receive it within a certain amount of time.
Mm-hmm.
With independent living, the AT part of it, it's not an entitlement program.
No.
So they get a certain amount of money, and
Right.
they will inevitably run out of money before
Right.
the end of the year, so they have to maintain waiting lists.
Well, and that is why there's requirements and eligibility requirements. And the same is true for vocational rehabilitation. It's not an entitlement. You have to be found eligible. And when we're thinking about vocational rehabilitation in terms of AT, the key word here is employment. And really with Voc Rehab, that is the key word all the way around. Their purpose is to help people with disabilities to secure employment through services that are needed to help them to do that. That's exactly what the CFR says. You must be disabled and require services to prepare for secure, retain, or regain employment. The arguments that you can make as an individual is that it's consistent with your strengths, resources, priorities, concerns, abilities, capability, interests, and informed choice. Interests and informed choice are usually the areas that I tend to work in when it comes to vocational rehabilitation. But when we're talking about assistive technology, what it has to be connected to is somehow connected to the employment that is being done. So is the individual needing a specific seat in the workplace, or a specific type of computer, or a larger screen, or do they need, is there a need for a lift on the car in order for the person to get to work? Modifications are always kind of tricky in terms of the legal arguments, so I'm not saying in any way, shape, or form that is always tied to employment, but there are times when it is. So the key with vocational rehabilitation is, how is that assistive technology going to help you to work, to get into work? And then it has to be a discussion between the counselor and the individual with the disability who's working with them to determine how it can be written into the plan. It's not something that you go in and say, I need assistive technology, and it's provided. It's written into a plan called an individual plan for employment. And at that point, that plan is what drives everything. And again, as clients have called us, sometimes it's that they do feel strongly that they need a certain type of technology for their work, for the ability to work, and that's where the legal arguments come in. Is it or isn't it required in order for that person to be employable? Here's some examples. I gave a couple earlier, but that could be related to employment that may be covered. There was also a blog post put out recently that had a list of them from the Utah Assistive Technology Program. So prosthetic or orthotic devices, eyeglasses, orientation and mobility services, vehicular modifications. Again, I am going to tell you openly that this has been an area of contention as of late with VR. So it really has to be connected to the need for work. Sensory devices, other technology, telecommunications. The argument, like I said, that we make is that it's tied somehow to the interest and employment of the individual, and is going to help them to be able to be employed. Special education. Speaking entitlement to eligibility, all students in the school setting are entitled to a free, appropriate public education. In special education, we call that FAPE. So you may have heard that acronym if you work in the special education realm. But once that being said, then there are individuals and students who need further or special education. When this happens, a parent or a school professional refers them to be evaluated for special education. Now, I'm going to assume for this presentation that the student has already been found eligible for special education, because that is a legal discussion that is completely separate from this, but can be an issue. But once a student is found eligible for special education, then the question becomes, is assistive technology needed in order for them to receive a free, appropriate public education? And this is where it runs into some issues, because it has to be related somehow to the schooling that they are getting and to their education. It can't be, well, I just really want my child to have this, or we're doing this at home, my doctor says it's a good idea, so we need to also be doing it at school. Well, that's a good piece of information that the doctor is doing it at home, and you should definitely provide that to the school, but it doesn't guarantee that assistive technology will be a part of the IEP or individualized education program that the student will have developed. Under the rules, just so you're aware, under the special education rules, which the State Office of Education, which means all of your district schools and all of your charter schools in the state follow, in Utah, I can't speak for other states, defines an assistive technology device as any item, piece of equipment, or product or system. And again, they go through all these pieces of how it looks, but to improve the functional capabilities of the student with the disability. So that's where we hang our hat when it comes to assistive technology in special education. How is it increasing, maintaining, or improving the functional capabilities of the student with a disability in terms of receiving an education? I'm going to take it a step further than that. Again, we're going to go back to this device versus service under special education, or IDEA, the Individuals with Disability Education Act. Services is any service that directly assists the students with the disability. So again, your school is most likely going to conduct an evaluation to see if assistive technology is needed. For parents out there, that means if you think that there's a need for assistive technology, you make a request of the school, and I would always recommend that that request be in writing, but you make a request of the school that they do an evaluation of the student in writing, specifically for assistive technology. Once that request is made in writing, I would also ask that you have a response from them within a certain amount of time, so that they either deny the request or they give you, okay, we're going to move forward and we're going to bring in an evaluator to evaluate the need for this. And again, if you're not happy with the evaluation, there's a whole other way that we can approach that. But again, that's a lot to go into at this time. Yeah.
So we have a question from Amber, and she wants to know if the school has to do the evaluation, which I'm assuming she's referring to an assistive technology evaluation.
The school is not required to do the evaluation, but if they're not going to do the evaluation, they need to give you notice as to why they are not doing the evaluation. And again, that's a legal argument to make. If you feel a need for assistive technology and you can tie it to how they're going to school, meaning, you know, my child needs a smart reader to be able to read effectively, they need that extra support, and the school's saying, no, we don't need that, and you've asked for the evaluation and they're still saying no, that's a good reason to call our office right there. But that's why I say do it in writing, because a lot of times we have people call us and say, I asked them, they said no, and it's your word against theirs. We could still move forward with the argument, but they're not required, in going back to your question, but they should provide you with some sort of notice as to why they're not willing to do it. And then we push forward with some arguments as to why they probably should do it. So there's some ways, even if they say no, don't just give up, I guess is my point. purchasing, leasing, and otherwise, this comes into play a lot too with students who their IEP, their plan requires assistive technology, but then they leave school and they're used to using a piece of assistive technology, and then they no longer have that technology because the school has purchased it and it's part of the school plan. This comes up as well. This is something we've dealt with a lot, and so know that there are avenues, some legal arguments that can be made. Not that the school should provide it, because when their time is up, their time is up. But is there other resources that are available that can cover the cost of that device? Is there other ways that we can make the argument that in order for this individual to work, they're going to continue to need some sort of device for communication purposes, those kinds of things. So keep that in mind. Just because it ends with school doesn't mean it ends. Yeah, go ahead.
So a continuation on getting the written consent of the school.
Yeah.
They wanted to know if email would count as
Yes.
writing.
Yes. Email is just as valuable as writing. Yes. Yeah. It's just
That's probably
it's
the standard
documentation.
way of doing things
Yeah.
these days.
Yeah. It doesn't have to be a handwritten item. It's just some sort of documentation that suggests that it's been done. I mean, we've even gone as far as notes from someone saying, on this date I made the request. It's just, if you just call us and say that you made the request, they can say, no, they didn't, and it becomes really hard. Actually, email's a little bit more effective because we have a record on both ends. Yeah.
So continuation on this topic,
Mhm.
if assistive technology is part of the IEP, then do the schools have to teach the parents and the child how to use it?
Well, depends on how it is written into the IEP.
Sometimes.
Yeah. Well, and if you look on the slide, training or technical assistance for students with disabilities, or if appropriate, the student's family. And then even below there, professionals, employers, or other individuals who provide services. So yes, but I think it's important to, if the IEP just states that we're going to use assistive technology and that's all it says, there's really not a good argument to make that other people need to be trained in it. We need to make sure that the IEP has a specific goal and specific ways that we're going to use the assistive technology as services. And those are usually written in on the IEP under the goal and then services and supports. So just keep in mind as you're writing an IEP, the more detail you can give, the better. And as a member of the IEP team, whether you're a teacher or a parent, because you're both members, you do have the right to make suggestions and recommendations that things are changed. So keep that in mind.
Mm-hmm. And I think one way you can make the argument that the parents, family members have to be trained is that if there's an expectation that the kid's going to be continuing that learning at
Mm-hmm.
home
Mm-hmm.
that they're engaged in at school,
Mm-hmm.
homework and so forth, as
Right.
presumably most kids do these days.
Yeah.
If they're going to be doing it at home, if they're going to be continuing to use that assistive device at
Mm-hmm.
home, then certainly there may be more of an argument that the parents need to be trained in
Right.
that.
Well, and I've had 2 or 3 cases, and I'm not giving anything away with this, just to give you an example where parent is using some assistive technology at home. The IEP states that assistive technology is used. It's not being used at school. The argument is clear. For them to get an appropriate education, it should be used at school, and the school and home conversation should be clear about how it's being used and how we can most appropriately use it for the student to benefit from education. So there is an argument to be made that training should be provided, and so if you feel like that's not happening, it's definitely something we can help you with if needed, even if we're just talking you through some of those things. Go ahead.
This is more of a clarification. This is from Anna Sherlock. She's at the Options for Independence Center here in Logan.
Sure.
And she just wanted to point out that while their funding for assistive technology is very limited, but in regards to eligibility, it is income-based and there is no need to prove disability. It is simply how they self-identify. So.
Thank you, and that's an independent living center, so thank you for clarifying that. And yeah,
Mm-hmm.
appreciate that. Thank you.
And
So-
good point. Anytime I misstate anything, just send a message in, point it out, and
Hopefully, least what we stated in the slide is true. And anyway, we'll keep moving. Assistive technology is part of a special education evaluation. So if you are just trying to get your student evaluated for special education services, make sure that when you sign that form that says you're going to do the evaluation, that assistive technology is one of the listed areas that you're going to address. It's hard to speak specifically to this because it's really on a case-by-case basis. There's not a silver bullet when it comes to education issues. It has to be related to a free, appropriate public education. Now, the reason I keep emphasizing appropriate is because under the law, education is not required to be the best. And for parents, the feeling is, I want my child to get the best education. And for schools, they want to give the best education as well. But the problem is there's a funding concern. And we live in Utah, so let's be realistic about this. There's a funding concern when it comes to schools. And so the legal requirement is appropriate, meaning that showing that the student is receiving a benefit. So when you think about this, show how the assistive technology is going to make for an appropriate education and how the student will benefit from that. Those are your two key words, so just keep that in mind. And I'm going to turn it back to you for medical.
Medical necessity evaluation. I should say before I start on these slides that a lot of you, if not most of you, have received today an email from our moderator, Story. It looks great. She was up until, I guess, 1:30 last night working on it, so make sure you look at it. And in the email, there is a section by Terry Holden, physical therapist, with some of the most typical documentation errors seen by the Utah Medicaid that leads to denials. And this really fits in. This gives actually some detail into what I'm going to talk about here with your medical necessity evaluation. In fact, Terry, these are slides from a PowerPoint that Terry and one other former employee of the Disability Law Center put together. So Terry, I know you're out there. If if I get stuck or like I said, if I say something wrong, send the message, correct me, and we'll go from there. So look at this, and that will give you some additional information beyond what I'm going to talk about. And also in that, there are 5 points, more tips from Anita Hall, who's with the Utah State Medicaid program. And I think when you're really looking at how to write a good medical necessity evaluation, and this is for all of you physical therapists, occupational therapists, speech language therapists out there, and then some vendors for devices. We're talking about putting in all the necessary information as it relates to, those medical necessity definitions that I talked about a few minutes ago, how, the private insurance company or the Medicaid agency or the Medicare agency defines a particular device or how it codes it. You really have to look at all those things as you're writing up your medical necessity evaluation. And I think that's essentially what Terry's elaborating on in this email. And that's also what Anita Hall is pointing out in her tips. And look at, her tip number 2. And I think that really helps clarify, the importance of the medical necessity evaluation. She talks about her experience with her husband as he was trying to get Social Security benefits. And it's the same issue with Medicaid. The people who are deciding whether something's going to be approved or not don't care what the doctor says is ultimately necessary. They want to see the proof of why it fits that medical necessity definition and why, that particular code, a device is necessary for this particular person. It's the best thing for them, and it's the least costly, most conservative, intervention or device for them. Think about that as you're writing your medical necessity definition. And then she also makes another good point, the last point, never say never. Take a look at that last thing of hers, and, if you're told no the first time, follow up, and if the follow-up doesn't work, call our office, call the Disability Law Center, and maybe we'll be able to do something
Well,
about it.
and I would say even call if you just have questions. I mean, even if you're trying to self-advocate and you're needing, you want to make sure you're headed down the right path, or just need to talk through some, it's a good reason to call. We can help walk you through some things if need be, so.
Mm-hmm. Okay. Just a few things that are on this first slide about medical necessity evaluation. Document the medical need, the diagnosis, and the functional limitations that arise from that diagnosis, how they impact someone's daily living, and so forth. And if, as LauraLee was talking about, as you're writing up that evaluation, if you're writing it so that, a school district may provide that device for the kid, make sure that evaluation describes how that device is necessary for that kid so they can learn. On the other hand, if you're submitting it for Medicaid reimbursement or prior approval, do not mention education, because Medicaid will not pay for things that are necessary for educational purposes. So you don't write all about how it's necessary for this person to learn math or whatever. It's looking at more functioning independently and meeting the impact of a medical condition, minimizing it, ameliorating it, and so forth. Don't refer to social needs. Don't refer to family needs. Okay. This is the list of the critical components: diagnosis, medical history, prognosis, developmental levels or evaluation results. And I think with developmental levels, that's probably going to be more critical with kids. You're going to want to see where a kid is in their developmental process, so that you'll know more about whether this device is the right one for them now, whether it meets their whatever limitations they may have in their developmental growth now, and whether a device may be necessary to anticipate developmental growth over the next few years. Photos are nice, summary and signature. And here's some more key elements to include. As in anything else, always have the correct medical diagnosis. We always hope we always give the right legal theory and the right cases. For healthcare practitioners, have the right medical diagnosis. And this next part, prevent the onset of an illness, condition, injury, or disability. That goes back to that medical necessity definition. And the next bullet point, reduce, correct, or ameliorate, that goes to that medical necessity standard for kids. Assist the individual to achieve or maintain sufficient functional capacity to perform age-appropriate or developmental appropriate daily activities. Again, that fits into that medical necessity definition, particularly for kids. Here's some other key elements. You're going to need to outline in detail the functional capacities of the person, because, I would assume most assistive technology is helping to address a functional deficit that the person may have. So obviously you're going to give a full picture of the functional abilities and the functional deficits of that the person may have, that's going to make for a more compelling medical necessity letter. And as you're looking at particularly more sophisticated devices, there may be research on how a particular type of device helps maximize the growth with a particular function or an intellectual process and so forth. More questions? Sometimes you're going to be asking for a device that the person's never had before. Sometimes it's just to replace an existing device, and it's going to be the same thing. Sometimes it's going to be a different device from what the person has been using. So obviously if the person's been using, has had a device, has been using it, you want to go through whether it's what they have, what they've been using, why it may or may not be working. Is it too small, or is it broken? That in itself, it may be a similar device, but if it's one of those two situations, then obviously they may need a different one. Particularly for kids, that's going to come up often. Medical diagnosis changes, that's probably going to result, that may result in a functional change, which may require a different type of device. So if there's a functional change, if it's tied to a change in the medical diagnosis, you really want to have, you really want to describe that change in the medical diagnosis. And, I can talk about all of these criteria. You probably, for those therapists and vendors out there, you probably know a lot of this better than I do, because I'm a lawyer with a history degree, so I've just picked this up along the way. Question?
Yeah. What would an assistive technology assessment look like? Is it just an observation? And this is pertaining to special education and the IEP.
Oh. Well, in terms of special education, this is how it works with most places in Utah. They contact UCAT, which is the Utah, I don't remember exactly what it stands for, something assistive technology.
Center for Assistive Technology.
Thank you. Utah Center for Assistive Technology, and they have teams that are directly related to the Utah State Office of Education. What they usually do is they come in, they observe the student in the classroom setting. They specifically look at what the assistive technology is being considered for and how the student needs it. They will write out a report of their observation, their recommendations, and so forth. And then usually it's signed off on. It depends on the necessity of the assistive technology. In some cases, everyone's just in agreement that something's needed and there's not a need to bring in other people to do an evaluation. But if it's part of an actual evaluation that's been requested, it's usually observations, and usually it's using, not going to say usually, sometimes it's actually using the device and seeing how it's different from when they're not using the device. So again, it's very dependent upon the individual, but there should be something that is written out and completed by the time they're done, that is a summary of what they've done, usually observations and recommendations. And if that's not provided, if what happens is you go in and they say, well, we just don't think they need it, or you just have like some observations written out by someone at the school, that's not a sufficient evaluation. Go ahead.
Yeah, another question, this is from Terry. She was hoping that you could address the time limits on denials.
In what context? In the
Medicaid?
Medicaid?
Since it's Terry, we're going to assume it's Medicaid.
Okay, let's talk Medicaid. Yeah. There's no strict timeline for a decision of approval or denial for a particular device or service, but based on case law and so forth, we use a 90-day period for making a decision, either approving or denying a service or device.
Do you want to finish this part?
Sure.
It's kind of the same.
Yeah, pretty much the same, but the first bullet point is it cheaper to modify or repair. I mean, that's just an example of that medical necessity definition where it talks about less costly, equally effective alternative. Will the requested AT prevent further injury or other disability? We had a client, and the issue was a power wheelchair. This person had been using canes and a brace, and he was still able to get around. But the problem was, as time went on, it was hard on his joints, his knees and his hips were wearing out. And, he could have been using those canes until, his knees completely dissolved. But, that's not an adequate criteria. So, in order to, and besides the fact that it was very painful for him and so forth. So, by having a wheelchair, and in his case the power wheelchair, that was something that would prevent further injury or other disability. So that's just one example of something that might go in the medical necessity evaluation. And there's obviously many different examples with different types of devices where the use of a device may not be essential for someone to engage in that activity, but it may be necessary so that some sort of injury wasn't suffered without being able to use that device. Yeah.
Terry just noted that it may be important to explain that on denials there is a time limit generally in which you need to send in an appeal.
Right. So for Medicaid purposes, and again, it's different between Medicaid, Medicare, and private insurance. Medicaid, you have to file an appeal within 30 days after the date that's on the written notice of denial. Okay? With Medicare, it's not 30 days, and I'm not sure what it is, so I'm not going to guess and give the wrong time. And with private insurance, it's going to depend upon the policy, the timeline. And one thing with Medicaid also, and it probably does not apply too much in the area of AT, but it might when you're talking about an assistive technology service. Maybe there's an ongoing service that's necessary to help train someone to use a particular assistive device. And at some point during that ongoing training, Medicaid may say, well, we're no longer going to pay for it. You have to appeal within 30 days. If you want that training, that service, that assistance to continue during the time you're appealing, it's in the appeal process, then you have to file your appeal within 10 days of the date that's on that written notice of denial. Yeah. Okay, so just the basic on when you get a denial, make sure it's in writing. Most all the time, it should be in writing. Every once in a while, it doesn't go that way. There will be instances where a type of device may be requested, and Medicare, Medicaid, private insurance may agree to provide another device, but not the one that's been requested. And there may not be something in writing initially that says, no, we are denying this one that you have asked for. In those situations, you're going to have to push to get the denial in writing, because that triggers the appeal process. And every once in a while, we run into the situation where you never can get the agency to submit, give you a written denial. So in that case, we just follow our 90-day rule and say, okay, if the device was requested for the service at point X and 90 days later there's never been a formal written notice sent out saying, no, we're not going to provide it, then we file the appeal.
In terms of special education, the denial in writing is not the denial of AT, it's denial of an evaluation. So if they're not willing to do the assistive technology evaluation, or if you actually have an individual education program, if they are unwilling to add that to the plan, you can ask for something in writing, but I think the best way to approach that honestly would be just to call us and say, I want assistive technology in the IEP, and not just I think it's important to look at it and say it's appropriate for the student to have it in the IEP, and here's my reasons as a parent as to why I think it's appropriate. And then that's something we could talk through with you and help you with. It's not that they're going to write on the IEP, we're not going to give assistive technology. They're not going to do that. So once they've said that in the meeting, you just come in and we discuss that. So that's how that would look. Mm-hmm. Anything else on that?
Yeah, the third bullet, contact the individuals that helped with the assessment to see if they can help. Mm-hmm. That's critical. For any piece of AT, an occupational therapist, physical therapist, speech language pathologist is going to go through and do the evaluation, presumably. Mm-hmm. And when it is initially denied, that therapist may be able to write an additional report to clarify any questions, although you're not going to find out from the written denial where the problems are. Mm-hmm. But through telephone calls or whatever, you may get some sense of what additional documentation may be needed. And they're going to be the ones that can provide the additional documentations. Certainly, if there's a formal appeal involved, an administrative appeal, we always get that therapist involved in the case. We may ask them for additional documentation, a new evaluation, a new report, or we may even have them testify at a hearing if it goes there. I mean, they are the experts. They are the true experts. They know more about that kid. They know more about that adult. They know more about that particular device than, your standard private insurance panel that decides whether something's going to be approved or not approved. Probably to some degree the same with, the Medicaid agency panel. So they are the critical people before and after the initial decisions been made.
And that's Medicaid and Medicare. I think we need to be clear too on the education side of that. That's a little different because the evaluation done by the education team is what drives whether or not it's a part of the IEP. Now, if the education team comes back with an evaluation you don't agree with, you can always request an independent education evaluation done by an independent party, and that's a process as well that is available to people. So just keep in mind when you're talking about the school setting, the information you get from doctors and those who diagnose is helpful, and it's important. It's very important, just like Rob said, but it doesn't decide. What decides is what the special education team decides. So just keep that in perspective. Use the information, bring the information. It's very important, but it's not the deciding factor.
Mm-hmm.
Okay.
Okay. Excuse me. And yeah, I've thrown into this slide a couple of cases that we've had having to do with assistive technology, not so much necessarily just for the purpose of that device itself, but it also kind of helps illustrate, you know, the broader issue of medical necessity and so forth. We had a case with speech-augmented communication devices, and the issue there, it was a case with Medicaid, and it was a case where Medicaid categorically would not cover speech-augmented communication devices for adults. And the way we actually were ultimately successful in that case is by making the legal argument, and the State Court of Appeals agreed, that speech-augmented communication devices could fall under the category of prosthetic device, under durable medical equipment, or under the speech-language category of services. And what the state Medicaid agency had done is said, we're going to consider speech-augmented communication devices only under speech-language services. And so since we don't cover speech-language services for adults, we're not going to cover speech-augmented communication devices for adults. That's just kind of that's an illustration of how those different categories that a device may fall into could become important. And, you know, when you're working with the Medicaid agency, the private insurance company, Medicare, you're not necessarily going to be able to get into the finer points of what category it comes into, because I know you're just working with codes for a particular device, and the Medicaid agency, the private insurance company may code it, and they may code it based on it being defined as a prosthetic device or as a piece of durable medical equipment. Right now we're having an interesting follow-up on our speech-augmentative communication device case, and this kind of shows the difference, where there's a real difference sometimes in the legal world about devices versus services. We went through the process, went to the Court of Appeals, and got a decision saying that our state Medicaid agency had to cover speech-augmentative communication devices for adults. So we went back. Our two clients needed to be reevaluated to make sure that the device that was requested initially was still the one they needed 3 years down the road after we finally got the decision from the Court of Appeals. Well, now we're looking at the issue of Medicaid is covering speech devices because of the Court of Appeals decision, but they're not covering evaluations for those devices or the subsequent training that's necessary once the person receives those devices, because again, that falls within that category of, you know, speech-language services. We're going to be able to resolve that, and I think we're going to be able to do it fairly quickly and easily. Of course, I've said things like that before, and I've been wrong, and it may not be as simple as I'm assuming, but you know, if there's any speech-language pathologists out there that work with adults that are, you know, concerned about that, or run into that, call us, call me. And then another case we have, it's ongoing, it's with power wheelchairs. And what we've run into in that case is the limitation on the type of power wheelchair that Medicaid will pay for, because Medicaid, you know, essentially defines power wheelchairs under that durable medical equipment definition, which talks about suitable for use in the home. So what the state, what our state Medicaid agency is saying is that any power wheelchair that we're going to pay for has to be designed for use in the home, and we will pay for a chair only for what is necessary for use in the home. So obviously the demands of a wheelchair getting from one room to another within a home is going to be different than what's necessary for someone
Traveling down the street.
going down the street, accessing all those activities in the community that we all enjoy. So that case, in essence, comes down to that in-the-home use criteria under durable medical equipment. We're fighting about that, and I think hopefully before too long we're going to resolve it. But again, that sort of helps illustrate this whole issue of categories of services, because this whole in-the-home criteria for wheelchairs is there because it's defined as durable medical equipment. A wheelchair could also be considered a prosthetic device, I assume. And under the Medicaid definition of prosthetic device, there is no in-the-home criteria for it. So ultimately that may be the answer for us. And I did want to put in a pitch, and I was emailing back and forth actually with Terry this morning about this. I would be interested to know from anyone out there, vendors, therapists and so forth, if they run into any problems with different types of assistive devices because of that in-the-home criteria, with devices that could potentially fall under the definition of a prosthetic device, the definition that we gave earlier. And think about that, and think about that definition of prosthetic device broadly. As I mentioned in our speech augmentative communication device case, excuse me, we were able to argue successfully that that device was a prosthetic device for purposes of Medicaid coverage because it replaced I'm drawing a blank on the definition of prosthetic device, but it replaces I don't know. Something or other, sorry. But, it can be a very broad definition. If you're ever running into problems with an in-the-home limitation with an assistive device, if you can think of it as falling within the prosthetic device definition, you're going to run into the limit. You're going to run into the problem because you're working with codes, and the codes may not give you the flexibility, calling it something else that may, so that it may be considered a prosthetic device. So I guess what I'm asking, as I'm thinking through this, I'm asking you, if you get a denial and it's a device that maybe could be considered a prosthetic device, call me and we can talk about it.
I think she has a question.
Yeah.
This is something I was thinking of, and I get asked this a lot, and I know it's something that Terry has also encountered, but in regards to AT in general, and then particularly in regards of an AAC device, but iPads, I know schools have their own things, Medicaid has their own thing, but maybe addressing that device in particular.
The iPad?
Yes.
The last I knew, excuse me, Medicare, Medicaid, private insurance will only pay for a dedicated device. So any device that's for a particularly, a medical condition. It's, at this point, it's insane because certainly an iPad can do everything that some expensive, sophisticated speech augmentative communication devices can do, but since it's not a dedicated device, Medicaid and those health insurance entities, they're not going to pay for it. On the other hand, schools will use them anytime they can.
Well, yeah, I mean, that's a challenge for schools, because if a student has an augmentative communication device that Medicaid's paid for, and parents and family feel that they should be using that device, but iPads are very available in the school setting and can be used for so many things. I mean, I have my own feelings about this, but I think that becomes a challenge, and so parents have to really consider what is going to be in the best interest of the child. And then that's the same for the school. If they're not able to provide them, if the parents aren't able to provide them with an iPad, but the school's using an iPad and not the augmentative communication device, and that's all they're going to have available when they leave school, you're putting a child at a disservice. So you've got to work that through in your team and determine what's appropriate for not just this year, but for the child as they leave the school setting. I think that's one, if nothing else, I hope that as people think about their education for their children, that they think about where is this taking them in terms of when they finish school, because school's not going to be there forever. So.
Mm-hmm. Go back that last one.
Oops. We're almost out of time, so.
Yeah. 5 minutes remaining.
Yeah.
Okay, I think I can do this in 5 minutes. That last bullet under power wheelchairs, and we talked a little bit about this in the home limitation. That is there under Medicaid and Medicare because of a device being considered, as I said, durable medical equipment. Durable medical equipment comes under the home health services category of Medicaid. At least this is the case for the Medicaid program. There's a distinct possibility that in the not too distant future that in the home criteria may go away entirely. The feds have proposed changing the definition of home health services, and part of that definition is changing the criteria for a service or device from being suitable for in the home to suitable for use in any non-institutional setting in which normal life activities take place. Now, we've been waiting for the feds to make a decision on this change for 3 years now. Apparently it's tied up because of the ACA and trying to get states to buy into expanded Medicaid, but hopefully the politics will finally be done with that. And if the proposed change comes out in final form, you all may not have to deal with that in the home criteria limitation anymore.
So if there are questions, we're happy to answer questions that you may have.
We do have one more, and then I think we're going to wrap it up. There's a few things I'd like to go over. Amber asked, if the parent buys the AT for the child and the school allows them to use it in the IEP, is this considered FAPE, F-A-P-E? I'm not familiar with that. I'm sure you are.
For appropriate public education.
If the school says yes, she can have AT on her IEP, but nothing is listed and never gives AT to the child, and the parent does, is it on, and does on their own, is this not a FAPE? I mean, and she clarifies, this wouldn't be considered FAPE, right, because the parent is paying for it.
Well, if it's on the IEP, then the school should be paying for the assistive technology. So I would want to go into some more questions with you about what's going on, but a parent who is sending assistive technology to school, the team's agreed to use assistive technology, then the school should be providing assistive technology that she's using at the school. So I guess it sounds to me like in this situation that you have assistive technology in the IEP, but it's not really clear what and how it's being used. And And if you'd like to call, you can call and ask to speak to me specifically. The number's on the screen right now. Just ask to speak with LauraLee Gillespie, and I'll be happy to talk to you about this, Amber, in more detail.
I guess it just comes down in the end is that device necessary to learn X?
Yeah, but I think her question is more in terms of if she's bringing the device to school versus the school providing
Right.
it and who's required to do so. So
Right.
I'm happy to talk to you more if you'd like to.
Okay. Well, we would really like to thank Rob and LauraLee for being here today and sharing their expertise. And as you heard, you are definitely welcome to call the Disability Law Center. And of course, you're also welcome to call Utah Assistive Technology Program. I do want to encourage you to remember to take the evaluation. That link is on the bottom of the AggieCast page, UATP survey. You can leave ideas for future trainings here, as well as how you felt things went today. And several of you asked if this will be available later. It will be archived on YouTube. It will be in a few weeks, and I will send that link out when it is available, and it will be closed captioned. And I also wanted to mention some resources from our program. Our foundation is sort of another last resort option when other funding fails from Voc Rehab and Medicaid and special education. A couple of things to note about that is we do have loans, and those applications are online at uatf.org. And the loans are half of prime interest rate. I believe right now that's 1.65%-ish, which is fabulous. We partner with Zions Bank to do that. And that can be used to purchase any AT device. There's no proof of disability required. That serves all ages of Utahns. Again, this is only for Utah people with disabilities. And the minimum is $500, and the maximum is $50, and I should note that can also be used for home modifications. Then we also have small grants that are available. Those applications are also online at uatf.org, and those are for people who are at 150% of the poverty level or below, and those are a maximum of $400, and those may require an evaluation to see that we're getting you the right device. And you can call our 800 number to inquire more about that. And then also to note our reuse program. We have donated mobility equipment sent to our CREATE program in Salt Lake. We refurbish it to essentially brand new, and we have a variety of manual and power wheelchairs and scooters, and those are the costs range from $100 to about $500. And it's a service fee to cover the cleaning, repairs, and new batteries if need be. And that information is available at createutah.org. So if you're hitting a roadblock with everything else, we're here to fill in those gaps. Again, thank you for your participation today. If you requested a certificate and have not emailed me your mailing address, I need you to do so, or I will not be able to send you one. And we are finished with our online trainings for this semester, but we'll be back in the fall with those, and watch for my emails on that. And thanks for your participation.
Thank you.